지금부터 시작해봐 앞을 달려 Running running 세상에 소리쳐 막다른 길이 나타나도 난 괜찮아 지금부터 시작해봐 앞을 달려 Running running 너와 함께라면 모든 날 속에서 끝없이 달려봐 거친 세상 속
Hi and Assalamualaikum. My name is Nur Sabina Sarah Binti Zakaria. Today I and my friend Hazwani will explain regarding questions 1 in our case study which are under Employment Act 1955 which state any three right or protection given to employee with respect to termination and layoff. So the first protections or right given to the employee is under Part 11, Article 60J, Clause 11, terminations, layoff, and retirement benefits. The article stated that the amount of terminations or layoff benefits payment to which an employee is entitled from any terminations for reasons other than retirement, misconduct, and out of their own volitions. So every layoff that is intended to be made must have a strong reason. So the employee cannot dismiss the employee at their own will, and if this happens, the employee has the right to claim compensation for the dismissal done by the employer as stated in the Employment Act 1955 and as protections given to employee upon the termination and layoff. The Employment Act 1955 also stated that the employer shall be confined to payment of indemnity in lieu of notice and other payment that the employee is entitled to as if no misconduct was committed by the employee. So referring to our case study, all 50 plans employee including Siva and Haris have been terminated by Mr. Bala and the decision happened out their own volitions. Therefore, they are entitled to get the benefits from their termination in regards to Mr. Bala action. That's all from me. Next, we move to Hazwani. Thank you.
Hi, Assalamualaikum. My name is Nur Hazwani binti Muhammad Razali and I will be presenting about the second rights of protection that the employer can get. Okay, the second rights of protection given to employee with respect to termination and layoff is a notice of termination of contract. Under Part 2, Article 12 in Employment Act, which stated that in Article 12, the party to a contract of service may at any time give to the other party notice of its intention to terminate such contract of service. The length of notice of termination shall be the same for both employer and employee and shall be determined by a provision made in writing in terms of the contract of service. Giving the employee or in other situations employer the notice for termination is very important because it is one of the conditions that contained in the contract of service. The length or the period where the employer is issued the notice to the employee is based on how long the employer has been working. The law stated that employer should give 4 weeks notice if the employee has been employed for less than 2 years on the date on which the notice is given. While 6 weeks notice if he has been so employed for 2 years or more, but less than 5 years on such date, and 8 weeks notice if he has been so employed for 5 years or more on such date. In this case, the employer or Mr. Bala has sent termination notice to plant's employee, including Haris and Siva. Thus, they are entitled to receive the wages that they earn until the day their contract has been terminated, and the employer is responsible to give the termination benefits to the employee who being terminated. The third right of protection is the employee can issue report or complaint to Director General if the employee is unsatisfied with the termination. Under Part 17, Article 70, this article stated about the procedure that the employee should do to give the Director General power to inquire the complaints and take any action or decision pertaining to the complaints. Article 60 L1 also stated that the Director General may inquire into any complaint from a local employee that he is being discriminated against in relation to a foreign employee. This is the legal action that every employee can do when they are unsatisfied with their termination or layoff. This is also one of the rights or protection given to the employee regarding the termination to protect the employee from being discriminated against the employer. In these cases, Siva and Haris can lodge a report or complaints to the Director General within 60 days from the date on which the decision of termination is communicated to him, either orally or in writing by his employer. The notice of their termination and regarding the matters that they are being terminated and replaced by the foreign worker.
Firstly, the regrettable law that Mr. Bala has contravened is the Employment Act 1955, which she should provide adequate letter or remuneration to comply with the job contract and also pay retrenchment rewards in full compliance with employment service agreements. Besides that, Industrial Relations Act 1967 states in Section 5 that no manager may discriminate against an employee because he is a union member. Therefore, the manager is required to give the worker reasons for the termination. It's all part of the process of natural justice. Any termination letter must explain the rationale for dismissal under Malaysian labour law, and the employer is obliged by Malaysian labour law to provide the worker with a notice of termination that details the explanation for the termination. Mr. Bala needs to justify Haris and Siva's action for being troublemakers. That's why he needs to explain the reason behind their termination. As for Haris and Siva, they comply with the Employment Act 1955, where they have right to join trade union. And in Industrial Relations Act of Section 4, they safeguard employees' right to unionize and emphasizes that employers are not permitted to meddle with such rights. Meanwhile, in Section 5, Clause 1, Clause B, and Clause D of the Act prohibits employers from refusing to hire or dismiss a member of a labour union. A worker who has been fired without justifiable reason can file a complaint to the Director General of Industrial Relations to demand reinstatement according to Section 20 of Clause 3. Employees who have been unfairly dismissed have the power to grant compensation, back wages, and reinstatement. Lastly, in Employment Act of Section 60 or Act 265 states that no manager has the right to dismiss the employment of local employees to hire immigrant labour. Because immigrant workers are always less expensive than local workers, there has been a trend to lay off local workers in favour of foreign workers. The phenomenon came to a halt in 1998 when the Employment Act was amended. However, workers' fair wages, overtime salaries, and payment deductions were all covered by Act 265. As the Act, a manager who refuses to provide all these rewards to an employee can face legal action in the Labour Court. In summary, yes, Mr. Bala has contravened any provision of the Employment Act 1955, where he terminated the services of Haris and Silva and replaced them with Indonesian workers because, according to laws and Act in Malaysia, the employer must have strong and reasonable reasons to dismiss an employee. Besides that, Mr. Bala has against the law under Section 60 of the Employment Act, or known as Act 265, where an employer could not terminate and replace local workers with migrant workers.
According to the Employment Act, all salaries employee who do not earn over 2,000 ringgit per month and all manual labour are protected under this Act, including the legal foreign workers in Malaysia. In Section 2 of the Employment Act, foreign workers are described as non-citizen employees, which means that foreign workers are also included in the employees term provided by the Act in Malaysia. There is no distinction between local and non-local. Consequently, any legislations that apply to employees in Malaysia also applies to foreign workers, which also covers the implied condition of the employment contract, such as payment of wages.
Beginning January 1st, 2019, employer will recruit foreign workers except domestic servants must register their employees with a SOSO and contribute to the employment injury under the Employee Social Security Act of 1969. Foreign workers who have registered with SOSO can claim benefits such as funeral benefit, medical benefit, rehabilitation benefits, and dependent benefits. In funeral benefit, if an employee dies while receiving of an employment injury, funeral benefit will be paid to the eligible person. If a foreign worker dies in Malaysia and is repatriated to his or her home country, the foreign workers employment injury scheme pay a funeral payment of 6,500 ringgit Malaysia. A funeral payment of 2,000 ringgit Malaysia will be paid to the qualified beneficiary of a foreign worker who was injured in Malaysia but died in his or her home country as a result of the injury. In rehabilitation benefit, rehabilitation refers to rehabilitation therapy provided to persons who disability as a result of accident or disease in order to improve their level of capacity and overcome their difficulties via the use of certain therapies. Except for dialysis, vocational and return to work service foreign employees have access to physiotherapy, work therapy, audiology, optometry, speech therapy, and clinical psychology.
Alright, firstly, action can be taken higher sensitive is prohibition on terminating a local employee for hiring a foreign workers. There is no employer may terminate a local employee's contractual agreements or services in order to hire foreign worker. Employment termination due to some reasons such as the workers doing such a criminal or harassment. In this case, Harris and Siva cannot be terminated because they are the local employees that have the rights stipulated in this act, and Harris and Siva can report this to the Director General of the secondly, dismissal without giving a notice. Right, so the dismissal was made by Mr. Bala. It is unfair dismissal occurs when the employee fires you or forces to leave without a valid reason and fails to the dismissal processes. In this case, Siva and Harris will be terminated without a notice or there is no solid reason from the employee Mr. Bala. Harris and Siva can report this to the Director General of Labour and action can be taken. The third one is the Trade Union Act. Services contract must not limit the employee's rights to join, participate in order to organize trade unions. In any service, contract cannot limit any employees who is a participant to such a contract's ability to join or register the trade union. To engage in the activities or the registered trade union, whether as an official of such organization or otherwise. The third one is to form a partnership with any other person for the purpose of forming a trade union in the accordance with the Trade Unions Act 1959. Harris and Siva can report to the nearest labor department and the Ministry of Human Resource.